Today's 2-minute update explains the new paid sick leave for certain federal contract workers triggered by President Obama's executive order last fall and a new OFCCP rule issued in February. This new rule kicks in for certain federal contracts after January 1, 2017. The DOL's proposal applies only to a very limited number of federal contracts, essentially the same federal contractors and subcontractors subject to that minimum wage rule that went into effect last year. Who's covered? 1, contracts under the Service Contract Act. 2, certain construction contracts under the Davis-Bacon Act. 3, concession contracts with the federal government. And 4, contracts for services to federal employees or the public on federal property or land, such as a child care center, gift or coffee shop in a federal building, or lodging in a national park. As a result, the sick leave rule is limited to a very small number of contractors. It doesn't apply to federal contracts for goods or supplies, and is estimated to impact less than 20% of federal contractors, half of which already provide paid leave. Kelley, what are some major provisions?
Well, employees who are working on covered federal contracts must be provided with 7 days of paid sick leave per year. Employees can accrue 1 hour of paid sick time for every 30 hours of federal contract work, up to 56 hours in a year. Alternatively, employers can simply grant covered employees 56 hours at the start of the year and not track it on an hourly basis. Employees are able to use that paid sick time for their own illness or health reasons that are far broader than under the FMLA. Employers can only require certification from a healthcare provider if a leave extends for 3 days or more, although FMLA rules may still apply. Employees can carry over unused paid sick leave to the next year, but employers can cap that at 56 hours per year at any given time. There's also no right to cash out unused sick time upon termination of employment.
Most importantly, federal contractors can use an existing benefit program to satisfy these new requirements, but you'll have to integrate any new provisions. DOL guidelines are expected this fall, so stay tuned for updates.